Welcome to What to Do When, a podcast from real lawyers with real perspective, where we explore a variety of legal issues and scenarios. Each week, we focus on a new topic and discuss what to do when and if any of these legal scenarios ever happen to you or a loved one. With over 40 years of combined legal experience, our hosts offer their unique perspectives and insights on a range of real-life legal situations.
Hey guys, this is Jackie and Scott from Critzer Cardani. We're here today to start a new podcast called Legal First Aid for Parents or a Dummies Guide to the Legalverse.
And today's episode, we're going to really focus on juvenile criminal defense and what that looks like from before kids are in trouble and arrested, maybe in trouble at school, all the way through to the end of a case and how to get there, what that feels like, what that looks like. Scott, where can you start guiding parents on, maybe a parent whose teen has just gotten in trouble, maybe just at school, something fairly innocuous?
Well, I think the biggest thing that we have to do as parents is educate our children as to their rights, their constitutional rights. And it sounds extreme because we want our kids to be these honest kids who are forthright. And a lot of people think when you do the things I'm going to start talking about that you're shading that. But we have to start to rethink and re-educate ourselves that not everybody has the right to hear your story. Not everybody has the right to have information from you just because they want it. Nobody has the right, and that goes right into the Constitution and why it's written that we have the right not to incriminate ourselves. And so many young people incriminate themselves from the minute they start. And most of the time, by the time a case gets to me, and I've been doing this for almost 30 years, by the time a case gets to me, he's already spilled the beans, told his story, and I'm in repair mode. And a lot of times, there may or may not even have been a crime.
But what's the problem with telling the story? It sounds like you're saying they shouldn't tell their story, but what's the problem with telling their story?
The problem with telling their story is they don't know enough to tell the story. There's so many things out there in the Legalverse that you can run afoul of by talking. You can actually incriminate yourself for other charges that you didn't even know existed. And it sounds crazy, and I know that, and for most of us, we probably never experienced this, but in our hyper culture right now, there's so much out there that we have to just be so careful and reevaluate and say, you know what? I get called down to the principal's office, Dad, what do? You don't say anything. You don't write anything because they always ask you, hey, write a statement. What if they ask your kid, hey, I'm going to search your book bag, your locker. Is that okay with you? The minute they say, is that okay with you? They don't have anything. Because if they had something, if they have what's called probable cause, it's really not called that in juvenile law in a school, but it doesn't matter. If they have a reasonable belief that something's going on there, then they can search. So them asking you to search means they're fishing. And you don't want to be the bait. So the best thing you can do is say, with all due respect, no, thank you. I'd rather you not search my locker. You can talk to my parents.
So is there a difference between a student's book bag versus a locker? And let me tell you why I'm thinking that just as a parent and a high school student one day, probably not very long ago, is that we were always told that the locker, that's school property. They can get in anytime they want. You can't stop them. And now, as a more seasoned attorney, I understand there's a reasonable expectation of privacy in a locker, maybe, definitely in a book bag. Is there a difference between a book bag and a locker?
A lot of things go back to what you signed when you entered the school and those kind of things, those resources. But we can get into all this and it gets really deep. But it really needs to stay really simple. Just don't give them permission. If they search it anyways, you bring the case to me and let me ferret out if they violated your constitutional rights or Jackie, and we can figure that out for you based on us looking at that stuff. But as a parent, we need to have a simple guide to this Legalverse. When we were talking about this, we were laughing about the Hitchhiker's Guide to the Universe. Because you don't need to know what creates the stars and the moons. You need to know how to get from A to B. And especially as a juvenile, even an 18-year-old, some of you parents have really dumped a lot of resources into your kids wanting the best for them. And you're at this point, they may be 16 or 17 years old, and all of a sudden they're in trouble. And you're seeing their college and opportunities dwindle, or whatever they're going to do, maybe a sports career or something, dwindle because of this mistake.
Well, let's talk about that. What if you've got a teenager, maybe scholarships are on the line, any sort of criminal record is going to be a problem. But let's talk about what happens when there's maybe a reckless driving ticket, or even underage possession of alcohol, underage possession of marijuana, because even though it's legal, it's not legal for everyone. So you start running through these crimes that are they on their record forever? How worried do parents need to be? There's so many questions.
Again, I think this is where parents really don't understand the law, and there's a lot of technicality here, but the bottom line is people are looking at it. It used to be your juvenile record was held off and nobody could really get to it, but that's just not the case so much anymore. And again, when you're applying for a college application and they ask you these questions, then you risk lying and all that kind of stuff. So it's really, people need to understand a reckless driving is a misdemeanor in Virginia.
Is it a misdemeanor even for a teenager?
Here's how it works. The code says it's a misdemeanor if done by an adult. However, parsing that out as a juvenile and on all these applications and all these things is really difficult. Almost not worth the fluff, because quite frankly, most of these things we're just talking about are charges that can be reduced or taken off your record and completely gotten rid of, so you don't have to answer that question if you take the proper steps, if you don't get yourself in trouble, and then depending on the jurisdiction, how the judges treat that. But we got to remember, juvenile law was created to be a chance, a correction, a diversionary kind of thing where it's not supposed to be punishment oriented. Obviously, if you keep going back and back and back. So there's a lot we can do as attorneys with a conviction, or not a conviction, but with a charge that in other courts may not be possible. There are a lot of things you can do even in the other courts, but when we're talking about juvenile law, there is just a breadth of things that can happen.
So now let's move forward. You've got a teenager who's been ticketed for whatever reason. Mm-hmm. Pick a reason. What happens after the summons what's a summons? I mean, they have a ticket. Ticket's a summons?
Yeah, I mean, a summons is you get a ticket on the side of the road that says come to court on this day. So you're summoned to appear in court. So that's how that works. If there's a warrant or a detention order with a juvenile put out on you, then you pretty much get arrested until you come to court. So let me stop there, because this is really important. Jackie and I talk about this all the time. Some parents are so fearful of getting arrested that they want their kid to talk to try to get out of being arrested, because the cop's going to say, hey, if you just tell me what's going on, and you don't know how many times I heard it, if you just tell me what's going on, nothing will happen to you. Mm-hmm. Well, if you did something wrong and you tell them what you did wrong, something's going to happen to you.
For sure.
So that's not truth, and they're trying to just get you to talk about it. The worst thing you can do is talk about it. So even if they're risking and saying, well, we're going to throw you in jail tonight if you don't talk about it, sometimes you have to look at your kid and say, it's okay. We're going to get you on the other side. And I'm sorry this is happening to you, but it's not okay to talk.
Short-term pain for long-term potential gain.
It really is, because what ended up happening if you do talk at that moment, you've already admitted to it. And again, when it comes to me, I've got a acknowledgement that I did whatever I did. Or it's worse yet, an acknowledgement I did something else. So it's really important. I tell my kids all the time. I mean, I have a almost 20-year-old now who had his fun in high school at times, but he learned really quickly, if I don't say anything, they don't have anything. And that's really, if you talk to a police officer or a detective that you know in the community and you ask them, how many times are you actually able to solve the crime by yourself? And they'll say, very rarely. Without that cooperation from the person who did it, it's very, very hard normally. Now, I'm not saying that so you can get out of trouble. I'm not saying that we should be skirting the law all the time. This is your constitutional right. This is what they're supposed to prove, that you did something. You're not supposed to prove it for them.
All right. So now that there's a summons, maybe they're in jail, maybe they're out of jail. Can you talk about what happens if the kid is taken to jail, of all places? Do they go to jail? Is there a place where they can be held for the parents to be called? What does that look like?
All right. Usually, in almost every case, they would go to the detention home for the night. Usually in most jurisdictions, they're arraigned pretty immediately. But when you're in the smaller jurisdictions like Goochland, and some of these courts only have court 1 day a week. So it would really depend on how the juvenile court process works and whether once they're arrested, sometimes the probation officer or the person working in that field may agree to do a detention order where they're being held, or he may say they can go home and return on a summons. So he has a lot of power to control that. But the bottom line is you're going to do something in that moment, but you're not going to jail. I'm not saying the detention home is great by any means, but you sleep on a cot for a night and hopefully the next morning you go before a judge. And unless you have some kind of crazy, serious crime, you're most likely going to go home.
Well, and as a teenager, does a teenager get to call their parents? Do they get, or their aunt, uncle? Can you phone a friend, phone a relative?
Yeah, most of the time, 90% of the time, the cops are going to be involved in that.
The cops will be involved in calling the guardian or parent.
Yeah,
or
somebody's going to be calling you. Most likely, you're not going to have. It's not like he's going to be locked away, tucked away, because they understand that you're a parent. You're probably worried about your kids, so they're going to do all those things. It's not like when you're an adult and they don't even know if you have somebody you're worried about. So you're going to get a call.
All right, so the kid's been arrested, maybe in jail, maybe not. There's a summons to return. You said a key word. You said arraigned. What does that word mean?
Okay. So you have this stuff we talked about pre-arrest. Giving information when their detective may be investigating. And then you come to court and that's your first day. Basically, what an arraignment is when you come to court and the judge says, hey, here's your charges. Do you want an attorney or do you not want an attorney? Sometimes you plead guilty or not guilty in that time frame, but it's really what the arraignment is about, and what the arraignment is done for is to tell you what you're charged with and to give you your right to counsel. So if you as a family are struggling financially, they have to provide you with an attorney if it's a crime that would put you in jail or cause some kind of detention time. I said jail, it's really detention time.
Can you take an attorney to an arraignment?
You certainly can, and it's always prudent to do that. And even if your child's locked up, that's the most prudent time to have somebody there at the arraignment, because they're going to address whether he stays. In that moment, they're going to address whether he stays in the detention home or comes out. So that's really, really important. So really, that's a pretty short hearing. A lot of times there's not prep work, but they're looking at your home, how you are as a parent, whether this kid can be protected and whether society can be protected in that moment. And I'm trying not to be too legal about this and just trying to be more general, but they're just looking at your child's safety and the community's safety in that moment to see, hey, is this going to be a good fit?
Well, you say something interesting, and I don't think we need to get into it in this episode. We'll do another episode about it. But is social services or child protective services going to be getting involved if your kid's gotten in trouble and you said they're coming to your house? Is that something people need to worry about, or is it a yes, no, let's talk about that on another? Yeah,
it's a yes, no, let's talk about it. It just depends on the situation. But for most crimes, we're talking about like trespass, stealing, a reckless driving, those kind of things. No, not at all. They're not getting involved. It's really when the child's safety is kind of becoming an issue that they may or may not get it. And I'll say it that way. I think it's just when safety is really a big issue. But for the most part, no. They're not going to get involved in a crime. Not at all. Now, I'll save it. Sorry, I know we said save it, so I'm moving on.
All right, so they've been arraigned. Now what's after the arraignment?
Then they'll set a date for trial. Sometimes, at that moment, there's a lot of power. This is where a lot of the power of attorney comes in. So, if I've talked to the parents and set things up, we may set the next hearing as a status hearing, which means we're not doing anything in the next hearing. And maybe that's because I've said to the Commonwealth, my client's going to do a bunch of things before here and the next trial and really try to work this off, so to speak. And if he does those things, we can look at it at the status hearing. They don't often say, hey, I'm not going to charge your kid or go forward the trial if you do X, Y, and Z. A lot of times they're saying, why don't you do X, Y, and Z and let me see how I feel about it at the time. And I'm going to have more time to talk to the victim or the school or whatever and really get a little bit more background and see if this is a case that should be kind of given the first bite at the apple, we call, a chance to redeem themselves. And a lot of times they are given that chance. I'd say more often than not, a first-time person who's going to the court, a juvenile who's going to the court the first time, is going to get a chance to redeem themselves. Even pretty serious. I've had cases where a kid took a gun to school and all kinds of stuff, and every one of those, the judges have worked around trying to give that kid every opportunity to work that off. Sometimes it works, sometimes it doesn't. Depends on the severity of it. Okay. I've had lots of them, but there's a lot of factors in that.
That sounds more like the strategy to try to avoid where we first started, which is criminal conviction on a juvenile record, having to report that to colleges. Yes. Then enters, but if they've spoken to the police or they've given multiple versions of their stories, then your job during that time is more difficult.
It's much more difficult. Again, if they haven't spoken, they may not even have been arrested. They may have avoided the arrest because nobody knows what the heck really happened. And if they are arrested, there's probably just not enough evidence to get it through. And Jackie and I always tell our clients when they sit down with us, one of the first things we say, especially in difficult criminal cases, we say, do not talk to anybody, period.
Well, do you mean
done?
Police, principals, teachers?
Anybody, especially your social group, your friends. You don't talk about it anywhere, because remember, anything you say to those people, somebody can come in and say, oh yeah, he told me all about it. He told me this, this, and this, and this. Maybe helpful, maybe not, but you shouldn't be talking about it at all, because you don't know how your conversations, or maybe you're just ticked off and you're venting to your best friend, and it just comes off weird, and you say something and she gets a red flag saying, oh, and you were really just angry and you said the wrong thing and you didn't mean to say, I did it, but.
Well, and depending on the level of crime will depend on how many people they talk to in your social sphere, your familial sphere, your school sphere, of course. Absolutely. Social media. Can the police or investigators see your social media? So many people think it's private.
Yeah, I wonder about that. Absolutely. And it's amazing to me. Everybody thinks Snapchat. All the kids do Snapchat because they think once they snap and it goes away that it's gone, and it's just not. I have had officers show me months and months and months and months of Snapchat that I would have rather not see ever, and so it's very, very, very not what you think. As they say, once it's on the internet, it's on the internet forever. Once you snap it out there, it's there forever. Can everybody get everything? No.
Right.
But the likelihood of them being able to get it with the right computer savvy person or get your phone, So again, we're just trying to go through the basics, but so you're going to be at this pretrial. At that pretrial, you're either going to set a status hearing or the date for the trial. And at the date for the trial, again, you're going in, and if you get that far and you don't have some kind of deal worked out with the Commonwealth, you're actually going to put your case on. And that means the Commonwealth in Virginia, a lot of people in other states are called district attorneys or stuff like that. So if you come from another state and you don't know what Commonwealth attorney is, it kind of helps a little bit.
The prosecutor.
The prosecutor is going to come in and they're going to say, here's my evidence, Judge. They're going to put the officer on probably first and say, what did you find out in your investigation? Well,
and maybe the principal, and maybe your friend, and maybe your mom, and
or the kid that was hit, or, it's like I said, it's really interesting, especially in driving charges. A lot of kids wreck. And they get this thing called a reckless driving. It's a misdemeanor in Virginia, which is crazy. But more importantly is 95% of the time, nobody saw anything. They're driving down a road by themselves and they overcorrected or did something simple. And the cop comes and says, did you drive the wrong way? And you go, yeah. So you just admitted to a reckless driving charge. When you just say, with all due respect, officer, I'm just not comfortable talking about this. And he'll probably give you a ticket for reckless driving. But when they go to court, the officer's going to stand up there and go, what happened? Well, I got there and the car was in the ditch. Okay. Did the gentleman make any statements? Did the young lady make any statements? No. And then at that point, I'm going to look at the judge and go, Judge, I have a motion to strike. We don't know how he got in the ditch. They have to prove how he got in the ditch. And that case is dissolved immediately. That's completely different than speeding. If they're going 108 miles an hour and the state trooper is sitting there with his gun clicking them, obviously. But even then, it's not okay to go when they pull you over and go, were you speeding? Yes, I was. I'm so sorry.
I was in a hurry for whatever reason.
Better thing to say is, with all due respect, officer, I understand what's going on here. I'd rather not speak.
So when is the best time for the parents to talk to an attorney?
As soon as you get wind that something's going on, even if you think potentially something might come down the chain. For instance, your son or daughter was at a party and you understand from the community that Johnny and Jimmy have been arrested for something at that party, or you heard something happen at school and you talk to your son, well, I may have snapped something. And, social media is a huge one with the cyberbullying and stuff like that. Say your son's in a group chat with 20 of his friends, and Stacy decides to go crazy and call Jimmy a moron, and then it gets back and forth, and then she says, I'm going to kill you, or I wish you would die. Why don't you go stick needles in your eye? And then all of a sudden there's these cyberbullying stuff that can come out of it. And your son's just part of the group chat, and he may or may not have responded. And how did he respond? And all that stuff becomes, and the first thing they're going to do is, I want to see your phone. I want to do this and that. And again, you can't stop them necessarily from taking your phone or taking your computer unless the attorney's already involved and maybe be able to do something. But the bottom line is you don't give them permission. With all due respect, no, I don't want you to look at my phone. Thanks. And you call us to say, okay, we're going to go through it and we're going to talk about what happened. And, that's where you need to be honest in that one-on-one conversation with your attorney. A lot of times I tell parents, and this is really key, parents, a lot of times I'm going to ask you to leave the room when I talk to your son or your daughter. And the reason being is, if you're sitting in the room with me and we discuss it, they can subpoena you to be a witness against your very son that you're trying to protect. So it's better for me sometimes if you're not present and I can just sit down and say, what happened? Jackie and I have this story from a long time ago where we had a kid charged with certain charges. And, we had the parents go out of the room and we asked him what really happened. And when he told us what really happened, we realized that this was really about hurt feelings and not about the client doing something completely wrong. And eventually, once we got that information and could work with that and work with the Commonwealth Attorney and all these kind of things, we were eventually able to, because he didn't make a statement, he followed our advice, he didn't talk about it, he didn't do all these things. Eventually that case actually went away because they just didn't have the evidence. And that happens a lot. And sometimes somebody scorned and mad is going to go, Jackie smacked me, when in fact she didn't smack me. And, because Jackie didn't say anything, eventually sometimes that person will get a conscience and say, that really didn't happen. I'm not going to go to court and testify over that because it didn't happen. But, that's what we're talking about. This process can be very long. It can go on for months sometimes.
And the first steps you take can have a major impact on how the rest of this journey goes.
Yeah, it's so amazing, as I sit there. And, and I tell people this all the time. We're in court a lot because of the nature of our practice. And I sit in court sometimes and watch people just throw themselves on the altar, so to speak, for something they really probably wasn't even a crime. And they're admitting to it and they're getting this conviction, or even if it's taken under advisement, which is a big thing I'll talk about real quick. Taking it under advisement means basically the court's going to say, there's enough evidence here to find you guilty, but I'm going to hold on to this case and give you a chance to work it off, and I'm going to make you do this, that, and the other thing, community service, maybe a program, maybe a shoplifters program, something like that.
Right. And
then I'm going to set it out for 6 months, and if you come back and done everything I asked for you, then I'll reevaluate whether I'm actually going to find you guilty or guilty for what. So they have some flexibility. All right, like we said, I'm going to go back to this take it under advisement, which means the court holds it and for a period of time and says, look, I'm going to find there's enough evidence here to find you guilty. However, I'm not going to find you guilty right now. I'm going to give you a chance. Maybe they're going to ask for community service or for you to do a program like a shoplifters program or some kind of payback, so to speak, to the court to show that you're serious and this was a mistake. And all that is so really important. As we said, when you start the right way, you're not already convicted, you're not already in a bad place, and the court has a lot more flexibility about what they can do and can't do because you go from the arrest, the arraignment, to this trial. And then even after the trial, there's a dispositional period sometimes where the court may say, come back later for disposition. I have enough evidence. But if you've talked or you've done all these things and helped them, then at this trial phase, it might be more of a slam dunk and there might be a little bit less that your court's willing to do. And so often they just don't have what they need to seal that deal. And when you come to us and you've talked to us about it and we can help you through it, we just want you to know that you have rights, number one. Even in school, you have rights. And giving up your rights isn't helping anybody.
Right.
And kind of think it like this time, sometimes parents. I want to say this last thing, I think, and we'll shift a little bit, but think of it this way. You protecting your constitutional rights keeps the guard up. So we keep police officers from doing their job, or keep police officers doing their job. If we don't keep our constitutional standards up and make them prove their case, then eventually what we see is the erosion of our rights, and all of a sudden they're knocking on our doors or telling us what to do and what we can do and can't do, because we've just lost that. And when Jackie stands up for her rights as a student, then the next time they go to another student, they realize they have to really maybe walk through this a little bit better and actually do the job and dot the I's and cross the T's and all that stuff. And we're just building that protection. And I love police officers, great people. You know, there's always bad ones and stuff like that. It's not about making them the bad guy, but it's about making them do their job. We do our job. Everybody does their job. That's how our nobody understands sometimes how our system is set up, but it's so intricate in everybody doing their job. And as our framers and founders said, it's better for 10 guilty people to go free than one innocent man to be one day in jail. And that's the mindset we have to have, because we are protecting the society by doing our part. And it really is important. It makes a big difference. And I know it sounds crazy, but I promise you, it'll sound crazy until you get a phone call about your kid, and then it's all kick in and go, oh, this is real now. So always think about that. Always think about you're teaching your kid his constitutional rights or his driving rights, that he doesn't have to tell the police anything other than his name, give them their driver's license, and give them insurance information. Other than that,
and protecting their futures,
and protecting
from whatever fallout could come that may not come for being less chatty about what's going on. So that's the summary of juvenile criminal defense, and another episode that I think is important for juveniles. We talk about juvenile sex crimes, and I don't mean juvenile prostitutes, but sexting or texting pictures back and forth. And is it okay if your son has pictures from his girlfriend of her different body parts and nude pictures, and same thing for the girl? Is it a problem for the boy to send her pictures of his private parts, and when is that a problem, and how does it become a problem, and how that can lead to a lifelong rap sheet that has a sex crime in it? So that's on another episode.
Alrighty.
We hope you've enjoyed this episode of What to Do When. For more episodes, be sure to subscribe to our podcast, and we encourage you to check our archives to listen to previous topics. Tune in next week for a new episode and some fresh perspective from Critzer Cardani.